The Illinois Supreme Court has just ruled 4-3 against plaintiffs who are suing to challenge, in the case of Caulkins v. Pritzker, linked in the description box below, the so-called Protect Illinois Communities Act, otherwise known as PICA, which among other things bans so-called assault weapons, assault weapon attachments, .50 caliber rifles, because we all know what a menace those are, as well as, of course, so-called large capacity magazine, i.e. normal capacity magazines. We're going to be talking all about it right here, right now. Guys, let's get into it. So if you want to know more and all the gritty details about what PICA did, not the video for you. I did do that video, but this is not that. In this one, we're talking about the Caulkins versus Pritzker decision. If you want to see all the nitty gritty details about what PICA did, what it tries to do, and all that kind of stuff, check that out, linked in the description box below to see our videos on that topic. So what are we talking about in this case? So in this case, Caulkins, who's the plaintiff, that's the pro-gun side, is suing Pritzker, that's the Illinois governor, who back on January 10th of 2023 enacted the Protect Illinois Communities Act, which banned all sorts of things, including, as I mentioned before in the introduction, those pesky .50 caliber rifles, which we all know is just a regular menace to society. Can't go a single day without opening up social media and whatnot and seeing another mass shooting with .50 caliber rifles. Well, this particular case, the plaintiffs filed in Macon County, Illinois, and that particular court entered what's called the Declaratory Judgment in favor of the plaintiffs on two different claims. A declaratory judgment is basically saying, look, you're right. I'm declaring that this whole law is done, or at least it's done on these particular grounds for these particular reasons. Declaratory judgment means that a court's basically just declaring, in other words, somebody doesn't have to run afoul of the law. Someone's just suing, saying, look, this law is no good for these particular issues. Of course, that's a brief instruction of what declaratory judgment is. Don't hold me to it in all particular cases, but for our purposes, that will do. They claimed, among other things, two particular issues, that the restrictions are facially unconstitutional. So we're talking about the restrictions against possessing certain types of weapons as well as certain types of magazines, because the exemptions, there are people who are exempted, deny law-abiding public the equal protection and constitute special legislation under the Illinois Constitution. I will be telling that to you in English in a moment. The defendants, that is to say the government, appealed directly to the Illinois Supreme Court. Okay, so what the heck are we talking about? And in short, it is not what you think we are talking about. We are not talking about the Bruen decision from 2022 or Heller from 2008 or anything specific to the Second Amendment. Illinois did not have to generate some kind of tortured and twisted fact pattern of history to support their firearm laws. Why are we not talking about Bruen? Because the Illinois Supreme Court ruled that the pro-gun plaintiffs failed to properly and timely raise those particular challenges and issues. You see, generally speaking in court, there are rules that you have to basically raise certain arguments at certain times. This is not like that time that you heard that couple drunk arguing at a bowling alley and they're basically playing a game of can you top this, as they take turns bringing up new arguments about who is right, citing particular violations and infractions against each other from the past. No. In court, it's kind of like that, but at least not in this particular respect. In court, the plaintiffs, that's the person who's suing to initiate a lawsuit, must generally allege that any and all of their arguments that they want to make in the specific case at the time of filing. Now, sometimes, under certain circumstances, they can add to that later and expand the breadth and scope of their arguments, and sometimes supplement and add additional arguments in. But many other times, they cannot. Whatever they led with means that that's what we're going to be talking about. In a nutshell, the Illinois Supreme Court ruled that the plaintiffs never bothered to sufficiently plead the Second Amendment issues, and accordingly, the Illinois Supreme Court does not need to do an exhaustive Second Amendment Bruen analysis, because none needs to be done, because the Second Amendment is just not part of this case. Now, if you're wondering why this is so incredibly important, I'm going to be giving you a quick recitation of what is the Bruen analysis at the end of this video, so be sure to stick around for that. It said the case was decided on two issues. First, equal protection, and second, whether the law constitutes what's called special legislation. It is important to note that the law created a very weak and limited exemptions for those who do register the offensive and regulated devices by January of 2024. To allow them to be grandfathered. You have to have owned them at the time that the bill was enacted on January 10th of 2023. Also, maybe a good time to mention that if you want me to prioritize my research on the history of when registration has led to confiscation, both in the United States as well as internationally, let me know in the comment field below. It's on my board, but I've got other projects that are frankly just prioritized above that, though of course that's an important one. Again, let me know in the comment field below. Why do I call the grandfathering clause weak? Well, all grandfathering clauses are weak in the face of registration. All too often that leads to confiscation, let alone, of course, infringement issues and challenges, but just listen to some of the restrictions on the so-called grandfathered weapons and magazines. The grandfather provision restricts where so-called assault weapons and so-called large capacity magazines may be taken. A grandfathered individual can possess the restricted items only 1, on private property owned or immediately controlled by the person. 2, on private property that is not open to the public with express permission of the person who owns or immediately controls such property. 3, while on the premises of a licensed firearms dealer or gunsmith for purposes of lawful repair. 4, while engaged in legal use of the so-called assault weapon or large capacity magazine at a properly licensed firing range or shooting sport competition venue. Or 5, while traveling to and from these locations, provided that the so-called assault weapon or large capacity magazine is stored unloaded and encased in a case, firearm carrying box, shipping box, or other container. Right, basically you're allowed to own it, provided it's going to be of no real use to you outside your home. That's the long story short on that. That is the reason why that is a particularly weak and pathetic grandfathering clause. But enough of my editorialization, back to the case. The law also exempted 7 classes of individuals, largely based around their involvement with law enforcement, the military, or security organizations. But when you create special rights for some while excluding others, in our case, people who are not military, law enforcement, or members of registered security and organizations, you create possible equal protection and special legislation attacks. In brief, equal protection clauses guarantees that similarly situated individuals will be treated in a similar manner, unless the government can demonstrate an appropriate reason to treat those individuals differently. The threshold question in equal protection analyses is whether the claimant, that's the person suing, is similarly situated to the comparison group. Evidence of different treatment of unlike groups does not support an equal protection claim. The determination whether 2 classes are similarly situated is not made in the abstract. Rather, the court must consider the purpose of the particular legislation in mind. The special legislation clause supplements the equal protection clause, and in many cases, the 2 clauses provide the same protection. They kind of get at the same ends through 2 different means, 2 different paths. The legislature enjoys broad discretion in making statutory classifications. That's code for passing laws and putting things in different buckets. But the special legislation clause prohibits the legislature from conferring a benefit or privilege upon one group while excluding other similarly situated individuals. The special legislation clause is intended to prevent legislative classifications without a sound and reasonable basis for discriminating in favor of a select group. So from here, now that you have the law, this is where the case then spirals downwards in analyzing these separate issues before ultimately, if somewhat predictably, deciding that the government wins, the law does not violate equal protection or special legislation issues. The issues are kind of dull and frankly very technical, even for me, and frankly not really that important to the larger issue of the Second Amendment. I have attached, as already noted, a link to this case if you want to check it out. It's in the description box below. I will note for those of you who are bold and enterprising, or maybe just in search of a good cure to insomnia, that the analysis starts at paragraph 44 on page 10 and goes through paragraph 79 on page 19. God be with you. Let's get to the good stuff. A quick recap of the super important Bruen test and why you need to know about it. But first, if you've gotten this far already, first off, congratulations for sticking around this long. Be sure to hit that like button, subscribe to make sure you don't miss any of our future, hopefully less boring content. Of course, don't forget, if you want to support our project, don't forget to hit that join button to check out our membership options. And I will also, of course, close with our ever popular quote of the day. So the Bruen test. The Bruen test is basically the test that was put into place by the United States Supreme Court to basically build a fortress, a defensive shield or perimeter against government regulation and legislation against the Second Amendment. Because you see, all the normal, ordinary tests that we give to determine whether or not a particular law infringes on the Constitution, strict scrutiny, rational basis, interest balancing, all this kind of stuff, Basically, what tended to happen all too often, I think, in the Supreme Court's view, is that the Second Amendment seemed to always lose those. Actually, the Second Amendment actually got the lowest level of scrutiny compared to any other constitutional amendment. Hence the term the Second Amendment was treated as a second-class right, which is true. More on that perhaps in another video. So what the US Supreme Court did is they said, look, now on, if there's going to be an issue affecting the Second Amendment, this is the test we're going to do. First, we ask whether the Second Amendment applies by its terms. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. That's from the US Supreme Court. Second, we ask whether a given gun restriction is, quote, consistent with the nation's historical tradition of firearms regulation, end quote. The government bears the burden of demonstrating a tradition supporting the challenged laws. Only by showing that the law does not tread on the historical scope of the right can the government justify its regulation. The second step basically requires the court to look to reasoning as well as history to figure out analogical comparisons that we can look at from times past. Bruen did not forswear all legislative innovation. In other words, they said nothing new can never happen. To the contrary, the Constitution can and must apply to circumstances beyond those that the founders specifically anticipated. So saith the Fifth Circuit, which is the most pro-gun circuit court so far we probably have in the country. But we are looking for it in tradition, well-accepted limits on the right to bear arms manifested by a tangible practice of comparable gun regulations. But how do we know whether an older regulatory practice is comparable to a new law today? Well, Bruen helpfully gave us two conceptual frameworks to look at this in. If the modern regulation addresses a, quote, general societal problem that has persisted since the 18th century, then the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment, end quote. But if a modern law addresses, quote, unprecedented societal concerns or dramatic technological changes, end quote, it calls for a more nuanced approach, which is code for the government does not automatically win. We must reason by analogy to determine whether the older regulations are relevantly similar to the modern law. Bruen acknowledged, this is the US Supreme Court, the difficulty of determining whether two laws are relevantly similar. Bruen clarified that two laws are relevantly similar if they share a common why and how. They must both address a comparable problem, that's the why part, and place a comparable burden on the rights holder. That's basically code for the how part. The bottom line is that Bruen instructs us that we are looking for a representative historical analog, not necessarily a historical twin. So there you are. That's a quick recitation of the Bruen test. Let's close with the quote of the day. For this one, we're going to, of course, English author and poet William Shakespeare. Quote, love all, trust a few, do wrong to none, end quote. If only that were so simple. Thanks for sticking around. I will see you in the comment section in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.